Here we have our second California community property hypothetical. Pure community property, not a crossover with wills or trusts, which frequently is the case. You would know what the subject was pretty fast on the bar because you see answer according to California law at the bottom of the page, which narrows it down for you. And then when you glance up above the 4 numbered items, you see what are Hal's and Wanda's rights and liabilities, if any, regarding. The H and W names on California's essays tell you that they mean husband and wife. And so you can be pretty sure that this is community property. Whether there will be a will or a trust in there, we don't know until we read the hypothetical. But we have Hal the husband and Wanda the wife. The first item is the condo. The second is a motorcycle. The third is a camper van. And the fourth is the A1 bank account. As Dr. Sakuso said in the webinar I posted for you, it's really customary in California to start a community property answer with all the basic definitions and basic rules. So define separate property, define community property. If quasi-community property is an issue, define it up at the start, so then you can just refer back to those definitions. Here we have Wanda, a successful accountant. Now, they don't give you extraneous facts in a California hypothetical. So the fact that she's an accountant is going to be important later on. Hal is going to rely on her expertise in some way. And Hal, an art teacher. So they're telling you that Wanda is more sophisticated about finances than is Hal, who are California residents, married in 2008. California residents, so quasi-community property is not going to be an issue here. After their marriage, Wanda and Hal deposited their earnings into a joint bank account they opened at Main Street Bank, from which Wanda managed the couple's finances. So that bank account is a community property account. Their earnings from their skill and effort during the marriage, that's pure community property. But that's not the bank account we're being asked about in Call 4, is it? Wanda also deposited some of her earnings into an individual account she opened in her name at A1 Bank without telling Hal. That's the account in Call 4. Without telling Hal. So this immediately opens up a couple of issues. First, that form of title is not dispositive. Interest is the key. So it doesn't matter that it's her name alone. It's earnings, so it's going to be community property. But the additional issue is that phrase, without telling Hal. So here I'm going to want to discuss with the grader that spouses are fiduciaries to each other. And in taking community property funds and putting them in an account in her name alone without telling Hal, essentially hiding them, she's violating her fiduciary duty to Hal. In 2010, Hal inherited $10,000 and a condo from an uncle. Inheritance, that's separate property. So the $10,000 and the condo start out as separate property. Hal used the $10,000 as a down payment on a $20,000 motorcycle. Let's see, that's Call 2. Borrowing $10,000 balance from lender who relied on Hal's good credit. All right, so I'm going to establish that this is separate property, and I'm going to have several issues here for this motorcycle. One is the loan, and what is the nature of that loan? What was the intent of the lender? Generally, if the lender is relying on only one of the spouses to repay the loan, you could consider it to be a separate property loan. But your credit during marriage is a community asset. So because the lender relied on Hal's good credit, that's a community property loan. Hal took title to the motorcycle in his name alone. The loan was paid off from the joint bank account during the marriage. Okay, we're in, as I said, call 2. The community paid off $10,000 of the value of the cost of the motorcycle. Separate property paid the other $10,000. That's what the interests are going to be in that motorcycle. It was a community property loan paid with community property funds, but it was a separate property down payment. So 50% separate property, 50% community property. So at dissolution, Hal has half of the value in terms of separate property and half of the other half in community property. Hal has 3/4 of the value, Wanda has 1/4. At Wanda's insistence, Hal transferred title to the condo, worth $250,000, into joint tenancy with Wanda to avoid probate. The condo increased in value during the marriage. That's call 1. What are we going to do with the condo? This, I think, is a much more complex call. That condo started out as separate property, so the issue here is whether titling it in joint tenancy transmuted that from separate property to community property. We have a presumption in community property law that when title is in joint form, it's presumed community. So the presumption the court will use is that that's community property. But Hal has an argument that that transfer should be void as far as ownership rights, because Wanda exerted undue influence. He relied on her skill and knowledge as an accountant to know what she was doing and not to change the form of ownership in his condo. And the facts tell you that it was to avoid probate. So if he can successfully argue that he relied on her expertise and that she failed to tell him the consequences of that title change, then he can shift the burden to her to try to prove that there was no undue influence. I think he has a very good argument that the joint title should be voided and that that condo is separate property. If the court does not do that, if the court believes that that property was transmuted, then the issue is, what's his interest in it? Because after all, he took $250,000 of separate property and gifted it to the community in that case. Separate property was used to establish a community property asset. So he would be entitled to reimbursement of $250,000 and then the remaining value of the condo over and above the $250,000 would be community and would be split 50-50 at dissolution. But he is certainly entitled at the very least to reimbursement of $250,000. Okay, next paragraph. We have, on Hal's 40th birthday, Wanda took him to dealer and bought him a used camper van for $20,000, paid out of their joint bank account, titled in Hal's name. Hal used the camper van for summer fishing trips with his friends. So what is this one? Right, it was his 40th birthday. It looks like it was a birthday present from Wanda to Hal, and maybe that's what was intended. But the rule in California when it comes to dissolution of a marriage is that in order to transmute community property into separate property by gift, you have to have a writing, an express declaration. And I do not see a writing, an express declaration here. It was paid out of the joint bank account. So again, the fact that it was titled in Hal's name alone is not dispositive. Interest is the key. This is going to be characterized as community property. He used the camper van for summer fishing trips with his friends. Okay, but that does not change the nature of it. There would have to be a writing to make it a gift. And the only exception to that is if this was of personal nature and negligible in value. A used camper van is not personal in nature, and $20,000 is certainly not negligible in value. So the exception doesn't apply here, but you have to analyze it. That's the exception to the requirement of a writing. Next we have in 2016, Wanda and Hal permanently separated. So now I write about legal permanent separation and what the implication of that is. Hal filed for dissolution just before the final hearing on the dissolution. Hal happened to discover Wanda's individual account, which contained $50,000. All right, does it matter that he didn't discover it until just before the final dissolution hearing? No, not at all. He discovered it. The court is going to look at that and say, community assets were used. That was a community account. That $50,000 is community property. But Hal is also going to point out that Wanda violated her fiduciary duty to him. And so the court will take that into account and will decide whether they should do a 50-50 split on that account, or whether in the interests of justice they should award more of it to Hal. They can deviate, and particularly when there's been some sort of fraud or undue influence, the court will deviate. Okay, those are the 4 calls. This is a bit more complex, I think, than the other one we did. The other one we did was difficult because it had the prenuptial agreement in it, and you had to know the detailed law in order to know whether that agreement was enforceable or not. But this one, I think, has more twisty little issues in it, like the fact that the lender relied on Hal's good credit, and you have to know that your credit during marriage is a community asset. Issues like that in this hypothetical. But if you take these one at a time and just analyze your way through, yes, it's a racehorse, but you can do this. Now, if it would be helpful, we can issue spot some crossover essays after I finish all of the subjects. But I really need to hear from people who are watching this video about what would help you. What kind of content would you like to see? And would you like more intensive involvement? Would you like to have access to, for instance, a Patreon channel where I could post PDF files with model answers or essay hypotheticals? Would you like to have the opportunity to be involved in live interactions where you could ask questions? Tell me what would help. And please help me beyond that by subscribing to the channel, by liking this video, by giving me some feedback in the comments about what you want to see. You can, of course, access a bank of over 100 past bar hypotheticals with model answers and or video debriefs from Dr. Sakuzo, Professor Poplin, and me in Power Law. The link to that is below in the description to this video. That also contains video summaries of every subject tested on California's bar and the UBE.